Well, good afternoon, everyone, and I will do my best to make this kind of legal analysis interesting. It's no small task at times. I'm going to minimize this. Can I minimize myself here? There we go. So, in having the conversation about independent contractors, Jeremy was right. It in so many ways comes down to the minutia. But the reality is, before we go down the road of actually having this conversation, I think it's important to figure out why we're here. It's a beautiful day outside. It's almost 4:30 in the afternoon on Thursday. You could be somewhere else. Why are you taking the time to listen to me talk about this? You know, it's never exciting to talk to a lawyer, despite the fact that I'm terribly delightful as a human being. So why are you doing this on an afternoon? The answer is because the Department of Labor really, really cares about whether or not the folks that you're using to do work in your business are independent contractors or are employees. There are significant penalties. This is the part of the presentation where hopefully I scare you into paying attention. So the IRS will charge you $5,000 per violation if your employees are misclassified. There are also treble damages for willful violations if in fact you knew that someone was misclassified and you continue to pay them in that way. There's also $5,000 per willfully classified employee under state law as well, and up to $25,000 for each subsequent offense. So even if you're not fascinated by this topic, I would suggest that it's worthwhile paying attention to it, just because the penalties can be high. So the question then becomes, why would you make a decision to take a risk? Why would you want to take a risk in this situation? Well, I'll tell you the answer is because you love the people that you're working with. You might decide to take a risk because everyone is getting along, everyone is in love, everyone is happy, and as a result, you decide that it's worthwhile to take the time and to take the chance and to potentially save some money, because nobody's ever going to call us out, nobody is ever going to fine us, and nothing's ever going to happen, right? So that's the concern there. One reason why you might take a chance is because you don't feel like paying payroll taxes, because you don't feel like paying overtime pay, because you don't want to give your independent contractors benefits or minimum wage or legal fees. These are all reasons why incredibly competent, smart people decide not to conduct the analysis that they need to, and to pay folks as independent contractors rather than pay them as employees. Now, what do you need to do in this instance in order to determine which way your folks go? You need to audit. And I, myself, love a good audit. Pathetic or sad, it's true. And if I try to phrase it this way at times for folks, either you audit the individuals who are working with you, or the Department of Labor will. And that's sort of up to you. That's your choice. And we can talk about sort of what that looks like when you do it yourself, and then we can also talk a little bit about what happens if the Department of Labor or the IRS comes in to audit you. In order to determine whether the people working with you are independent contractors or employees, let's first look at the Fair Labor Standards Act. So the Fair Labor Standards Act outlines 7 different factors to determine whether or not a person is an independent contractor or an employee. In many ways, the heart of all of this, the key test, is the extent to which the employer controls the individual doing work. It's an individualized, fact-intensive, subjective determination, which means that there's no clear answer one way or the other. The kinds of things that the Department of Labor is going to look at is the extent to which the services rendered by your independent contractor are integral to your business. The more integral, the more important they are to what you do, the more likely that person is an employee rather than independent contractor. They're going to look at the permanency of the relationship. Is this person popping in to do one service for you, or are they always with you? They're your go-to person. They're going to look at the nature and degree of control. And for this analysis, I like to think about this in a couple different ways. So what does that mean, the nature and the degree of the control? It means, what type of instruction are you providing for these folks? The degree of the instruction, so how intensely are you regulating their day-to-day activities? Evaluation, how do you evaluate what it is that they're doing? Are they doing a good job? Are they doing a bad job? Do you evaluate the process, the way that they do what they're doing, or do you focus more on whether or not they accomplish the end goal? And then also the kinds of training that you provide. And that sort of goes to the, how do you tell them how to do their job, or do you just say, do the job? So those are the kinds of things that the Department of Labor is going to look at. And the Department of Labor is the federal agency that regulates payment of minimum wage, overtime, and things like that. So that's why we care what they think about this, because if an employee is entitled to overtime for hours worked over 12 hours in a day or over 40 hours in a week, and you're not paying them, and then suddenly they are reclassified as an employee, you may be on the hook for that overtime and minimum wage going back in time for a number of years, and that can be a significant financial hit. So that's why you want to make sure that your folks are classified appropriately. Another thing that the Department of Labor looks at is the opportunities of the contractor for profit and loss. So what does that mean? That means that does this contractor get the same rate regardless of whether they do a good job or a bad job, or how long it takes them? Is it just a flat rate? You could also look at this from the perspective of overhead and expenses. Does the person that you're hiring pay their own overhead and pay their own expenses, or do you pay that for them? If you pay that for them and the employee is guaranteed the same amount of money regardless of how well they do the job, of when they do the job, things like that, then they are more likely to be employees than independent contractors. The other kinds of things that the Department of Labor doesn't care about, because I think that's important as well, is where the work is performed. The DOL doesn't care if this person works from home or if they come into an office. They don't care if there is a formal employment agreement. They also don't care whether an individual maintains licenses with state and local government or whether you do. And they don't care about how this person is paid. Now, interestingly enough, some of those factors that the DOL doesn't care about, the IRS very much does care about. And the reason why you care what the IRS thinks is because of taxes, right? Because we want to make sure we're paying attention to employment taxes. So let's think about that test. If you Google Internal Revenue Service independent contractor, you'll find out that there's a 20-prong test, a 20-prong test. Too many if you ask me. But the IRS will look at all of these different factors to determine whether the person that we're talking about is an independent contractor or an employee. Not one of these factors is completely determinative. So that means that if there's not one magic bullet for any of these things, it's always going to be sort of a bigger question of how many of these factors are met and how many are not, and then they'll sort of weigh it as they conduct their analysis. The IRS is going to look at things like training, integration into the business, which is one of the factors we talked about with respect to the Department of Labor. If you have to comply with the employer's instructions about the work. One that I think is important for the IRS, and it's important for you to think about too, is whether when you hire someone, they must perform those services personally. So if you hire a process server, Bob, and Bob is the one who has to serve the papers, I would suggest that that person is more likely an employee than an independent contractor with respect to that one particular factor. If Bob can take 5 or 6 jobs from you and your competition down the street and somebody else, and it turns out that Bob can't personally serve those papers but can hire out someone else, then Bob is more likely to be an independent contractor. If you think about this from the perspective of an in-house marketing person who you rely on, who's going to do all of this work for you, who knows who you are, who's going to do things in a particular way, and compare that person to someone that you might pick up the phone and call and say, I need a brochure, thanks. That's sort of one way you can kind of think about that. The first person is going to be an employee. They know how you do things. They're going to do things the way you want. They're going to do them at an office if you want. They're going to do things using the methods or the programs that you want. Whereas if you just pick up the phone and call someone else and ask them to produce a brochure, what do you care about? You care about, did you come up with a layout I like? Can I have 200 by Friday? And will you deliver them to my office? So there you're not controlling the way that they do things. They can do it midnight, you know, they can use whoever they want. They can do it from home in their pajamas. It doesn't really matter. But you look at that and say that person is going to be more likely an independent contractor. Both the IRS really prefers that you pay independent contractors a flat fee and not payment by the hour. So, for example, you could say, to serve this particular complaint, I'm going to pay you X dollars. That could be a flat fee. Question whether something sort of gets in the middle and you say, okay, we're going to pay you, $20 every time you go out and try to serve this. So you're sort of paying a day rate or kind of a piece rate for that kind of work. That feels more like an hourly rate, but it's not entirely an hourly rate. So that one would sort of be in the gray area, but the IRS prefers that. The IRS also cares if there's a continuous working relationship with the employer. What does that mean? That means that the IRS would prefer for it to be an independent contractor that someone sign an independent contractor agreement and that agreement be for a period of time. This person is going to work for you for a year, and unless they screw up, they stay. An independent contractor is much more likely to be a for-cause termination rather than an at-will termination, because at-will sounds like employee. Whereas some sort of for-cause or for a breach of the agreement, that person's going to be more of an independent contractor. And I suggest that eliminating things like for-cause language from your agreements entirely is a good idea, because that's a concept, again, we use more with employees. So when you're dealing with an independent contractor who is misbehaving or who you want to terminate, I would encourage you to think about it more as a breach of contract claim than an employment claim. Again, these distinctions may seem kind of picky or too subtle to matter, but I suggest they do matter to judges, and that's why we're sort of focusing on those. Under the IRS, they also really care about whether or not you require people to work on site at your premises, to do work in a particular sequence, or to submit status reports, or just even regular reports, or be paid at set intervals. So if you say, as an independent contractor, you take as many as I can get you and I pay you every 2 weeks, I would suggest that that person sounds more like an employee than an independent contractor who should just be paid when you pick up the phone and call them. An employee cannot make a profit or suffer a loss from the work that they do. They're just being paid for their hours worked. An independent contractor could. So you could have an independent contractor who's much more efficient at what they do, who's better at what they do, is able to serve things more quickly, and that person can make more of a profit than someone who's an employee who just gets paid for their time. Similarly, you could have an independent contractor who is more efficient because they sub things out. Again, they're getting someone else to do it for less than what you're paying them to do. That person smells more like an independent contractor than an employee. So those are some of the things that the IRS looks at. I can read you all the 20 factors, but candidly, you can Google that, or I can pass it to Kim and we can put it up on the website. One of the biggest indicators that someone has to come talk to me about an independent contractor relationship, one of the biggest things that sort of brings this to the forefront, in addition to the possibility of an IRS audit or a Department of Labor audit, is an application for unemployment. So if somebody separates and is no longer doing work for you, and they file a claim for unemployment, if they're an independent contractor, they will be denied. If they are an employee, you'll go through the traditional analysis of whether they were terminated for any fault of their own, or whether they were terminated because of no fault of their own, which would entitle them to unemployment comp. How do you ensure that your independent contractors are not under the incorrect belief that they're entitled to unemployment comp, and how do you make sure you're setting yourself up for that? You draft a really pretty contract, and we'll talk about that a little bit. Colorado has statutes that specifically deal with unemployment compensation as well as workers' compensation if they're injured on the job, and those statutes provide very specific language that you need to include in your independent contractor agreements, and interestingly, that language has to be, according to the statute, either in bold type and underlined, or it needs to be in a font larger than the other provisions of the agreement. Is that silly? I would suggest yes. Is it something you have to do? Is it something I've fought tooth and nail with the State Department of Labor over time and time again? Absolutely. They really do care about that. And if you follow that statutory language, the upside of that is you will enjoy the presumption that the person who's making the claim against you is in fact an independent contractor and not an employee. So that means that you sort of start off with a win, and then that person has to chip away by bringing up the other factors and make the argument that they're truly an employee. So I suggest that's something you want. The workers' compensation statute is found at Colorado Revised Statute Section 8-40-202. One other interesting fact about this, interesting potentially only to me, but interesting all the same, between the workers' compensation statute and the unemployment insurance statute in Colorado is that language about them needing to be in bold, underlined, or larger font is identical in the two provisions of the statute. I've given you the workers' comp, not the unemployment, but the language in both statutes is identical, except for one thing. Under the workers' compensation statute, it says that any signatures on an independent contractor agreement where the company hiring the other person is trying to not have to pay workers' compensation benefits has to be notarized. That's something that not all of my clients do. It's something that not all people do, but I will tell you that if you're going to push back against an application for workers' compensation benefits for an independent contractor, you are in much better stead if you comply with the statute and have that notarized. All right. Let's keep going. So then there are other tests to think about. Now, under Title VII, which is the federal statute that regulates discrimination in employment, there's a state statute, and a number of other different kinds of employment statutes. They apply slightly different analysis, but at the end of the day, most of them come down to control over the worker's work. So control over the way the person does their job, and whether you're providing things that they need to do their job. Are you paying for expenses? Are you providing them with the computer, with the tools that they need? So it's those two prongs. Some of the reasons why you care about these other tests is that I may be deemed an employee under, for example, Title VII, which would allow me to file a discrimination claim against you, but not be considered an employee by the IRS. So these are just sort of other reasons why you want to make sure that you're looking at all of the different factors, because the different layers of potential liability are so complicated. So to sum it all up, the things that you need to look at in order to determine if your folks are independent contractors or employees is the behavioral control, what kinds of training you give them, the degree to which you try and control them, how you evaluate their performance or whether or not they get paid, and the kind of instruction that you give them. Financial control, what are you paying for? What are you not paying for? How are you paying them? And then just generally the type of the relationship. What does it feel like? Does this person have, when I go out to serve for you, do I have to wear a particular kind of clothing? Do I have to wear a logo that is yours and not mine? Do you care what kind of software I use to provide you with the information? Do you care if how long it takes me to serve? All of these kinds of things. Just sort of how does it feel? And then that's not to say that by requiring your process servers to use a particular kind of software is going to automatically make them employees, or to require them to dress neatly when they do this. Is that suddenly going to make them employees? Those things are not necessarily determinative, but they are factors that go to an overall weighing of whether someone falls into one category or another. So, other than listen to me on a fascinating Thursday afternoon, what do you do? What do you do right now? You audit everything, I suggest. Audit everything you can. So, what does that look like? First, you're going to start looking at the business documents that you have that govern your relationship with this person. You're going to look at any sort of offer letters, any sort of independent contractor agreements. Do you have a job description? Job descriptions smell like employees. Independent contractor agreements smell like independent contractors. You're going to look at whether or not you provide them with business cards. Do you allow them to work for other people? Do you require them to work for other people? One of the factors that Colorado looks at is whether or not the people that you're dealing with work for other folks. In Colorado, the assumption is that if I'm truly an independent contractor, I'm actively working for more than one person. If I'm just working for one person, the assumption is that I'm an employee, not an independent contractor. So, in fact, some of the magic language that I referred to earlier in the 2 Colorado statutes requires folks to specifically include in their agreements the representation that the independent contractor is actively working for other people. So you want to pay attention to that. I suggest that it is irresponsible, or at least you're taking a significant risk, to not have independent contractor agreements with your folks if they're truly going to be out there and be independent contractors. Now, when we talk about this business documents, let's also think about not only what you can do to audit your own business, but also what the Department of Labor audit would feel like, or the IRS audit would feel like. What's going to happen if, in fact, and I don't know if any of you, this is where if we were live, I'd ask you all to raise your hand if, in fact, you had been audited in the past. But generally, you receive a notice, and you have a certain amount of time, sometimes as few as 3 days, to provide to whichever federal or state entity we're talking about a laundry list of documents. What kind of documents are they going to look for? They're going to look for documents related to the work that you do, how you advertise yourself, any sort of payment records for both potentially your clients, but definitely for anyone who's doing work for you, and any sort of agreements, anything like that. They're going to come in and look at everything. And unfortunately, they're not going to give you very much time to pull it together. So that's where if you have audited yourself and you understand sort of your own practices and procedures, it'll be easier for you to respond to this in short order. At the same time, I would also encourage you to consider conducting an internal I-9 audit. In my experience, if one federal agency comes in, be it ICE, immigration, if they come in, or if the Department of Labor comes in, they're going to talk to each other. They may deny that they do this, but in my experience, one follows the other. So I would suggest that as you sit down and look at the information that you have that describes how you interact with the people who do work for you, I would suggest that you also take a look at your I-9s. In my experience, the Immigration Policy Center and Homeland Security, when they come out and do an I-9 audit, they will fine you significant amounts of money. I've had employers with, double-digit employees, not hundreds of employees, end up paying tens of thousands of dollars in fines, not because their folks were undocumented, although in some cases they were, but rather because their forms were filled out incorrectly. They will charge you a certain amount of money for filling out the I-9 form incorrectly. What does that look like? It looks like your signature's on the wrong line, you didn't date it, the form isn't dated within 3 days of the employee's hire. Any of a number of small, seemingly insignificant administrative mistakes can cause you significant financial damage. So I would recommend that you take a look at those as well and just go back and ensure that they're completed appropriately. Other thing I think while you're taking a look at this is for you also to reconsider your own insurance plan. So as you take a look at the kind of insurance that you have for directors and officers and general liability, take a minute to determine whether or not you have employers' practices liability coverage. That generally covers things like discrimination claims. You can purchase usually a separate rider for wage and hour violations for things like misclassified employees who therefore need years of back pay. You can purchase those. Some folks decide to, some don't. But as you're looking at your insurance policy, I would suggest that you take a look and just know, it's not necessarily good or bad, but know whether or not if you have someone who you have classified as an independent contractor and they bring a discrimination claim against you that really should only be lodged as by an employee, if there is coverage for that or if you don't have coverage for that. So I would just say take a look at that in and of itself. And also check your E&O, your errors and omissions, just to see what kind of coverage there is for these kinds of things. As you make decisions about what risks to take, I suggest that determining whether you have insurance coverage to protect you in the event you do make a mistake is an important part of your overall analysis. I also recommend that folks take time to talk to their service providers and other sort of trusted advisors to determine what files you keep and what your record keeping and sometimes even more important, record destruction policies look like. I have had employees come in and say, or employers come in and talk to me and say, hey, we had an audit, but you will be so proud of me, Laura. I have documents going back for 20 years. You're going to be so proud of me. Well, the downside of that is you may not have needed to keep them longer than 3 years or 1 year after an employee is terminated, depending on what kinds of files we're talking about. But the fact that you do have them means that there may be additional administrative violations found in those documents. So I suggest that as important as it is to know where the documents are that you need to keep, it's similarly important to know when you can get rid of those. Also, as you're looking at your independent contractor agreement itself, as you're looking at those files, I think it's important to identify a number of specific things in that IC agreement. This is where I should probably give the disclaimer that I'm not providing legal advice, blah, blah, blah. This is merely a general discussion of legal principles and shouldn't take the place of true legal counsel. There, I've done my duty. So when you're drafting an independent contractor agreement, and I think we have a post coming up? No. When you're drafting an independent contractor agreement, I think it's important to, as I've mentioned, include the important statutory language for Colorado that indicates that those folks understand they're ineligible for unemployment insurance based on that income that they're earning with you, and also that indicates that they understand they're not eligible for workers' comp, and where they represent that they're actively working for other people. Those representations are important. I also think it's important to place specific responsibilities on them for taxes, insurance, business licenses, anything like that. If they have fees and that they have to pay in order to maintain licensed, or if you can require them to maintain a certain level of insurance, that can also be important and can be part of your conversation with your insurance agent when you're sort of reviewing your own coverage, would be to sort of take a look and say, how much would you like me to have my ICs carry? How much should they have? So that we're not creating a bigger problem here than we are solving one by requiring them to have insurance. I also think it's important to think about the requirements for how they do their job, right? So you don't want to include words like, we control what you do. You don't want to use words like that. I would urge you, to the extent possible, to consider only requiring compliance with industry standards or best efforts. Those two catchphrases are heavily litigated and mean something in the legal world, and I would suggest they leave a lot of that up to the process server to determine how they're going to do what they need to do. Then I think we talked at the beginning about the sort of, in sum, we were talking about how it's degree of control and financial control. I think that if you write your independent contractor agreement so that you are focused as the person supervising this person to helping them get done what they need to get done on the result, on having those brochures that are done, on having your toilet fixed, on having the end result be the trigger for payment and be what folks are paying attention to, I would suggest that person is more likely to be an independent contractor than an employee. Again, you're avoiding paying by the hour, day, or week. If you can pay by project or task, I think that's helpful. You don't want to require progress reports. You just want to know when things are done. You want to make sure that any independent contractor is specifically responsible for their own employees, for their own liability insurance, for their own unemployment and workers' compensation coverage for their employees, so that you're not on the hook for that, they are. And then all taxes. So again, we're putting the very same things we're afraid of getting tagged with on them for their own employees, because it sort of further bolsters the idea that they truly are independent contractors. Now, some of the struggle here is you will end up being in kind of a paternalistic education role with some of these folks. They come to you, they want to work, they may not understand the scope of what they're taking on when they agree to work for you as an independent contractor, and you need to make sure that this document shows that they understand the scope of what they're doing. If you offer benefits to some of your true employees, you may want to include a waiver that confirms that they know they're waiving the right to participate in any of those benefit plans. We talked a little bit about how you want to make sure that that contract is for a set period of time and not just open-ended like it would be for a normal employee. And again, because we're in Colorado, you want to focus specifically on the fact that they can train or they can work for other people. As you're focusing on sort of the files and record-keeping and destruction, I suggest that in addition to having beautiful policies and having beautiful documents, you also need to train your folks who are going to interact with these people, or make sure that you have the training to not somehow mess it up, so that the truth of how you're interacting with these people is the same as what your document says. Very often I will tell people, I can draft you beautiful contracts, beautiful policies, handbooks. They're amazing, they smell good, they're beautiful, they're just fantastic. But if you ignore them and if you run your business in a totally different way, then I suggest I might as well not have written them at all. So it's just a waste of time. So you want to make sure that the folks who are interacting with your independent contractors understand what this means. It means that you don't include independent contractors in employee meetings. You focus on their performance as a breach of contract issue rather than a performance issue. You're not putting them on performance improvement plans like you might, or a PIP like you might with your traditional employees. You don't invite independent contractors to company functions. They don't come to your holiday party unless, of course, you invite other vendors. You invite other people with whom you have a contractual relationship. You don't train them. You just don't treat them like employees. I guess it's the clearest way to say it, even though that's sort of clear as mud. Posters, also when the Department of Labor or Immigration come out to your site and look at whether someone is an employee or an independent contractor, they're also going to take a look at the employment postings that you have in your common area. Now that may sound crazy and insignificant, but there are also some fairly significant fines if you don't understand the kinds of posters you should have and that they're posted in a place where true employees and folks who are independent contractors can see them, because those posters will further clarify what folks' rights are. And so if you have those up, it's just another layer of protection for you that supports the fact that you are truly trying to make sure that the people you work with understand what their rights are and understand your understanding of what their rights are. And because we already know the feds love their own posters, it's going to be said in a way that makes the feds and the state happy, so why not use their own words? And that was it. That was about 25 minutes of rapid fire independent contractor and employment questions. I think, I hope that some of you have some questions, and I'd love to answer them. So how can I help?
All right, Laura, thank you. I'm going to jump back on here. As Laura said, if anyone has any questions related to employee versus independent contractor, feel free to jot those into the questions section of GoToWebinar. One element of this event, Laura, is that we have process servers from all over the country. Many are from Colorado, but we have, I think we're representing over 30 states. For those people, I know you mentioned some statutes and some resources to go to for Colorado, but if if I'm in another state, where would be the first place you suggest I go to kind of brush up on some of the similar elements that you referenced in relation to Colorado?
Well, I would be happy to provide you with a brief summary. I can get it to Kimberly to give you a heads up. I'd say about half of the states in the United States require language similar to what I mentioned for Colorado, which was specifically that you require folks to work for someone else, and so I'd be happy to provide you with that list. But where I would go first would be the State Department of Labor statute, or State Department of Labor website. So the U.S. Department of Labor, I believe it's usdol.gov. I think that's the federal statute or federal website. But each state is going to have their own. Sometimes they call it an employer's guide, or sometimes they have Q&As on this, and that will provide you with sort of the specifics about your state and what they're required to do, if you have to have that magic language, or if there's a slightly different version of that magic language, and whether or not it has to be notarized. Those would be sort of some things that I would take a look at. But generally, I would say if you follow the IRS test, that 20-point test, you're 3/4 of the way there.
Got it. We did have a question that came in from the audience, and that question is, what if your cash flow would not support paying an employee on a set basis?
The Department of Labor and the IRS don't care is the answer to that. So each state is going to have requirements about how often, if someone is an employee, each state's going to have regulations about how often and when you have to pay those employees. So, for example, in Colorado, you have to pay employees at least monthly, but each state is going to be different. But The federal Department of Labor, so generally state departments of labor regulate the timing of payments and when payments are accrued and when they're owed to the employee. So that's all about the when. And then some states also take the position that they can enforce the federal regulations as well, which is questionable on a constitutional level, but is potentially true, and Colorado does take that, that point of view. The federal Department of Labor is the one that's going to care about minimum wage and overtime. So but that particular question, if your cash flow can't support payment of employees on a regular basis, you're going to run afoul probably of both, because the feds care about minimum wage and overtime and the states care about when, so you're going to run into issues with both.
All right, well, I'm not seeing any more questions. Oh, well, hold up. The question is, will a state-specific addendum to a general independent contractor agreement be sufficient for state-specific terms?
Yes, I would. Well, I'm not providing legal advice. You should talk to your lawyer. That said, yes, it probably will, and that's not uncommon. I do that for handbooks kind of often. You know, for employees, you've got, here's the full set of everything that we need to do, and then you've got state-specific addendums about access to personnel files, you know, jury duty, you know, emergency leave in the event of a fire, you know, just other things that some states have and some don't. So I don't see any reason why you couldn't have sort of a master services agreement or a master independent contractor agreement, and then say, you know, incorporated in this are the state-specific terms in Exhibit A, which the employee agrees, you know, apply to this contract, blah, 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 and then make sure you're clear about which of them governs in the event of a conflict, the addendum or the standard agreement. You'll have to make that distinction. But if you, so you could do it that way, assuming you knew about the state-specific differences in advance of having them execute the original sort of template document, or your template document probably says that it can be amended in writing by a writing signed by both parties. So you could just have that writing signed by both parties and then have them execute it, and just that could contain that magic language.
Got it. How can our audience get a hold of you if they have any questions or they would like to talk to you about helping them out?
Best way is probably my email address, which is lhazen, H-A-Z as in zebra, E-N, at hklawllc.com, or we're online at hklawllc.com. That's where our website lives.
Got it. And Laura's name and firm is also on the ServeCon website. And you can also get a hold of us if you have any questions and you want us to get a hold of her for you. It looks like we had a couple more, maybe. Do you have time for one more, Laura?
Sure do. Bring it on.
All right. All right, I'm going to do my best on this one. All right, so if while under an audit the state finds one of the tests is being violated,
yeah,
would that automatically be a determination that all independent contractors are employees?
The answer is yes and no. So if during an audit the Department of Labor finds that that one person is not an independent contractor, they are an employee. So they're not going to focus on just one of the factors, they're going to focus on the majority of the factors, right? So it's sort of a factual weighing, but if they determine that more of the factors that suggest this person is an employee are there rather than factors that this person is an independent contractor, it will change the status of everyone in that class, in that category. So you could argue that some people they're different. You might have junior and senior, process servers. So maybe junior process servers are employees because they require more supervision, and senior process servers go off and do what they want, and therefore you could argue that they are different. I've had some success with that in the past, but not all the time. It kind of depends on your auditor. But the general answer to your question is yes, that determination would apply to the entire class of folks. Got
it. Laura, awesome job. Thank you so much. We really appreciate your time and the support of this industry in our event.
It's my pleasure, and be sure to feel free to reach out. I'm happy to, if there are specific topics that folks think of after the fact, I'm happy to contribute to blogs with additional information.
Wonderful. Thank you very much.